Hey everyone, welcome to The Explainer. If you're gearing up for the bar exam right now, man, I see you. I absolutely validate the stress you're feeling. Civil procedure and jurisdiction, it can kind of feel like this massive, impossible mountain of abstract rules. But hey, take a deep breath. Today, we're going to take that mountain and turn it into a clear, structured, high-yield visual review. We're going to map out exactly how to attack these questions, visualize the flow of the courts, and get you the practical tools you need to confidently put your thoughts down on paper.
So let's dive right in. Here's our agenda for today. We'll be hitting subject matter jurisdiction, thresholds and venue rules, drafting a complaint, the flow of appeals, Rule 65 and expanded certiorari, and finally, some absolutely crucial survival tips.
All right, starting with Section 1, subject matter jurisdiction, the foundation of it all. Before we look at the actual rules, let's do a quick mental calisthenics check. Here's a classic scenario straight from the professor's lecture. Okay, imagine a petition for the probate of a will. The estate is valued at 800,000 Philippine pesos. Is this case covered by small claims, summary procedure, ordinary rules, or special procedures? Take a second, think about it. Now, that 800,000 figure, it totally looks like a trap designed to push you towards small claims, right? But the actual answer is special procedures. Because it's the probate of an estate, it completely bypasses the small claims and summary procedure rules regardless of that peso amount. This is exactly the kind of issue spotting you've got to master.
And that brings us to what jurisdiction actually is. It's not just this one monolithic concept. For a court to validly hear and decide a case, it has to acquire 4 totally distinct aspects of jurisdiction. First up, over the subject matter, which is strictly defined by law, specifically BP 129. Second, over the parties, and that's acquired when the plaintiff files the case and pays the fees, or when the defendant gets a valid summons or voluntarily appears. Third, over the issues, which are conferred entirely by what's actually written in the pleadings. And finally, over the res, which literally means the actual or constructive seizure of the property in question.
Now, here is the absolute most crucial point to remember. Subject matter jurisdiction is handed down by the legislature, period. Bar examiners literally love testing this principle. You and opposing counsel cannot just sign a contract agreeing to give a specific court jurisdiction over a subject matter it doesn't legally have. No way. It can't be invented, it can't be waived, and it absolutely cannot be magically conferred just because the parties agree to it or stay silent.
Moving on to Section 2, thresholds and venue. Basically, the numbers game.
So if subject matter is the law, the thresholds dictate exactly which door you're going to walk through at the courthouse. For first-level courts, like the municipal trial courts, money claims must not exceed 2 million pesos. And for real actions, actions involving property, the assessed value must not exceed 400,000 pesos. Once you step literally one single peso over those limits, bam, exclusive jurisdiction automatically kicks up to the second-level regional trial courts. Notice that the absolute magic phrase for that 2 million peso boundary is does not exceed. If a claim is exactly 2 million pesos, it stays right there with the first-level courts. Examiners are going to try to confuse you. They'll make the claim exactly 2 million, or maybe 2 million and 1 peso, just to see if you bite. Stick rigidly to that does not exceed rule. But wait, there is a massive bar trap here you need to watch out for. That 2 million threshold is strictly exclusive of interest, damages, attorney's fees, and costs. The professor gave a really fantastic example of this. What if you sue for a 900,000 peso unpaid loan, but you add on 500,000 in interest, 500,000 in attorney's fees, and 500,000 in moral damages? That's 2.4 million total. So do you go to the RTC? Nope. Because your main cause of action is just that 900,000 peso loan. All those damages and fees are purely incidental, meaning they are totally excluded from this threshold calculation. You're still filing in the MTC. Now, when an examiner asks you about venue, the rules elegantly simplify into one fundamental question. Is this a real action or a personal action? That's it. If it involves the title or possession of real property, it's a real action, and your venue is wherever that property is physically located. If it's literally anything else, it's a personal action, and venue is simply where the plaintiff or defendant resides. Easy, right? All right, Section 3, drafting a complaint. Building your case. We've established where to file, but how do you actually build a bulletproof complaint that survives a motion to dismiss? Well, the core of any complaint is the cause of action, and a complaint that fails to state these 3 steps is going to be fiercely attacked. First, you have to explicitly allege that the plaintiff has a legally protected right. Second, that the defendant has a correlative obligation to honor that right.
And third, that there was an actual breach of that obligation. Take away even just one of these elements, and your complaint legally fails to state a cause of action.
Beyond the cause of action itself, your complaint has some mandatory structural elements. You've got to plead ultimate facts, the plain, direct facts of the claim without all the flowery language, right alongside your evidentiary facts. You must attach your judicial affidavits from the absolute start, but please, burn this next part into your memory. You absolutely must include the certification against forum shopping. If you leave this certification out, it's an automatic dismissal. And worse, it's a fatal error that a simple amendment cannot fix. Don't let that happen to you.
Moving on to Section 4, the flow of appeals. Let's climb the judicial ladder.
Visualizing the hierarchy of the courts is hands down the absolute best way to untangle appellate jurisdiction. Think of it as a logical ladder. So if you lose down in the MTC, you appeal up one step to the RTC, using Rule 40, where you can raise questions of both fact and law. Now pay close attention here. If the RTC was acting in its appellate jurisdiction, meaning the case started in the MTC, and you want to appeal again, you go to the Court of Appeals under Rule 42. But if the case originally started in the RTC and you're appealing purely on questions of law, you skip the CA entirely and go straight to the Supreme Court under Rule 45. Always, always ask yourself, is the RTC acting originally or as an appellate court?
But what if you aren't filing an ordinary appeal? Well, you need to clearly differentiate between an error of jurisdiction and an error of judgment. If a court makes a mistake appreciating the facts or interpreting the law, that's just a simple error of judgment and your remedy is a standard appeal. But if a court acts completely outside its authority or with grave abuse of discretion, now that is an error of jurisdiction. Your remedy there is not an appeal, but a special civil action under Rule 65.
Which brings us perfectly to Section 5, Rule 65, an expanded certiorari. This is easily one of the most confusing yet frequently tested distinctions on the bar exam. So a traditional Rule 65 certiorari is filed specifically against entities exercising strictly judicial or quasi-judicial functions. Simple enough, but what if a purely administrative body commits grave abuse of discretion? The professor highlighted this really fascinating case involving Bureau of Customs employees. Basically, they lost their overtime pay because of a purely administrative memo. Since it was administrative, traditional Rule 65 just didn't fit. So the Supreme Court actually allowed them to challenge it using the constitutional expanded certiorari.
Expanded certiorari is actually a constitutional duty under Article 8, Section 1. It dramatically expands judicial review, basically allowing courts to strike down grave abuse of discretion by any branch or instrumentality of government, even if they aren't performing judicial functions at all. Pretty powerful, right? However, the professor firmly reminds us, even with this expanded power, you are not exempt from the rules. You've still got to observe the hierarchy of courts, so please don't jump straight to the Supreme Court, and you absolutely must exhaust your administrative remedies first. And finally, Section 6, Survival Tips, taking care of your mind and body.
Okay, we've talked a lot about hardcore procedural rules today, but let's pivot to some incredibly vital advice for actually surviving this grueling review period. Here's a highly structured weekly routine to help keep you sane. Monday through Friday, study with all your might. Go all in. Then Saturday morning is purely for output. Practice answering bar questions to build up that muscle memory. Saturday afternoon, that's for memorizing those rigid rules. But Sunday absolutely must be for rest. The professor was wonderfully insistent on this point. Step away from the books, reconnect with your loved ones, reconnect with your body, and just rest completely so you don't burn out before you even reach the finish line. I really love this quote from the lecture. The bar will tell you what kind of a person you are and be open about it. Use this review period to really lean into your personal learning style. If you're a visual learner, draw out those flowcharts we just discussed. If you're more auditory, read the rules out loud to yourself. Trust your preparation and be radically honest with yourself about how you learn best. We've covered a ton of the structural logic of civil procedure today, from those rigid monetary thresholds all the way up to the flow of appeals. But as you head back to your studies, I want to leave you with this provocative thought. Knowing the rules is really only half the battle. Have you mastered the art of actually articulating them under pressure while still fiercely protecting your peace? Take a breath, trust the structure, and go crush your review. Thanks so much for joining me on this explainer, and I'll catch you next time.